going to take you through what it's about. I'm going to take you through what the difference is between the GDPR and the Data Protection Act 2018. I'm going to throw in some Brexit-related stuff as well, because that's important and things to consider off. We're going to have clear up some myths and go through what the specific requirements are under the GDPR. So, let's get started. First off, there's lots of myths around what data protection is. Everyone seems to think, especially when May 2018 came along, everyone seemed to think that data protection was about security, locking everything down, you shouldn't do this, you shouldn't do that, blah, 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 blah. And that's not quite true. It's unfortunate, most people take the word protection to be lockdown, security, and that's it. Well, actually, protection means a lot more than that. It does quite literally mean the effective management of, which includes security. It isn't just listed to security only. What a lot of people get wrong is, oh, data protection, that says I can't use personal data. Oh, data protection says I can't do this, can't do that, can't do the other. And again, that's not quite true. It's often a yes with conditions. So for those of you with kids, you'll often say to, when your child says, I want to go and play at the local park, all right, yeah, fine, but you'll be back by 12 o'clock. Or you won't go beyond the furthest gate, whatever. You will say yes with conditions. Life is yes with conditions. So data protection is no different to that. It is a yes with conditions. You can do that, but you've got to do it in these sorts of ways. Whereas many of the organisations that land themselves in trouble with data protection is because they've just gone off and baked a cake and not actually asked you or thought about what the cake is for. So to use the cake analogy, if I say to you, oh, Peter, can you go off and make me a cake? Would you just go off and do it? Or would you actually ask me a question like, well, sure, what do you want? What is it for? Is it for a wedding, a bar mitzvah, a funeral? What? How many people has it got to feed? Are there any allergies? Those sorts of things. Basic things so that I've asked for a cake and you give me the cake that I've asked for. Simple things like that. But because data protection is often thought about last, we come in at the stage where the cake is in the oven, by which point it's a bit late. You're already going to get a cake. Now, GDPR only talks about the handling of this thing called personal data. So it's very narrow in its application. And again, in May 2018 and leading up to, there was lots of nonsense around what GDPR covered and what it didn't. And it only covers personal data. That's information that relates to a living, identifiable individual. So you've got all the traditional things, app name, address, date of birth, those sorts of things. But you've also got things around their physical location. Because if, for example, my phone can separate out one person from another, so my physical location on my phone here is different to the lady next door's, then you've got two separate sets of coordinates. Therefore, you've got two separate things that can separate me out from her and vice versa. Therefore, it's personal data. You've got other things around criminal record, biometric data. So even if we just use the phone analogy again, if I've got the face scan and turn on for this, that's biometric data. I'm taking my face scan or my fingerprint scan and turning it into a piece of data. Therefore, it's what's known as biometric data. So yeah, if I've got these three elements of personal data, then I've got personal data. So it doesn't apply to the deceased. So you'll often get organisations trying to put or send customers through a process of dealing with, I don't know, account changes, things like that, when the person is deceased, and that won't work. Therefore, if you do, for whatever reason, have to get involved with the affairs of the deceased, make sure that there is a separate process for them. It can be similar. So, for example, only those with the legal authority can access such data and those sorts of things, but make sure that there is a process to handle it, because if you try and force that poor customer service agent to ask the member of public for the account holder's consent, and the account holder is deceased, then you're just going to land yourself in a load of trouble. In the UK, we've got something known as the common law duty of confidentiality. That governs the information on the deceased. There's no set act of parliament that deals with it. Instead, it's information, or it's a common law expectation that only you and the account holder will have access to that information. Anyone else, including wives, spouses, fathers, mothers, those sort of things, cannot. unless they've got a legal authority to, like a power of attorney or something like that. So if I've got those three things, I have this thing called personal data. If I have personal data, then the GDPR applies. So the question that you should always ask is, do you need personal data? Can you achieve what you want to achieve without it? Because if you can, do that. That way then you don't have to worry about the GDPR, you don't have to worry about the requirements of it, and it gives you some more flexibility with what you're doing. What the data protection also says is that it defines personal data into two types. So you've got the electronic data, so stuff that's on your laptops, your PCs, your phones, digital personal data, but it also talks about the stuff that's in your filing system. So the general rule of thumb is if it would take a temp more than a day to find something, then it's not a relevant filing system. Whereas if it takes less than a day to find it, then it is. So if you've just stored it by number, by name, by month, A to Z, then that's all relevant filing systems. Whereas if it's a general, massive, great big pile of ugh in the corner of the office, that's pretty much taking up the entire office. If you ever watch those programs about hoarders where they just fill their house with stuff, it has to be that sort of level of chaos for it not to be a relevant filing system. If you do ever have a scenario where you don't have a relevant filing system, for you public authorities, so councils, NHS trusts, police, blah, 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 then that's still personal data for you. The Data Protection Act 2018 explicitly says, look, the GDPR defines it as not personal data. We are defining it as personal data. So public authorities, if your archives, for example, are in a mess and you've got no idea what's in there at all, it's still personal data. You still need to go and sort it out. So bear that in mind. Therefore, personal data can quite literally be everywhere. It can be in your email systems. So when people I send an email, so for example, if I send an email to Leanne saying, hi Leanne, here's the file on Stuart, and attach said file, or then talk about that said file via email on Stuart to Leanne, then that's personal data. I'm talking about Stuart, it's very much relevant to Stuart, it's personal data. Now, if you've got what, thousands of staff, hundreds of staff, all then talking about different customers, other staff members via email, and that's just being stored in one massive, great big email store, it's then a nightmare to try and manage. But it is very much still personal data. You've also got the issue of phones now, and people can store stuff very easily on here. You can download apps that cost nothing and store personal data on there. So when you're looking at what staff are doing and how they're handling data, be aware of that. It's very, very easy for them to put stuff on a device that's either controlled by you or not controlled by you. So that's something that you need to factor in to what's happening with personal data. Also bear in mind that CCTV images are personal data as well. They're very much designed to identify someone. That's why you've got them there. They're there for health and safety, security purposes. So they're very much personal data. It's identify someone. It's in a digital format. It's personal data. So make sure your CCTV systems are GDPR compliant. And good old-fashioned traditional paper. Someone once said that personal data or GDPR outlaws paper, and it doesn't. So if you want to carry on using paper because that's legitimate for your business, you crack on. Whereas if you want to move to digital, you crack on as well. Choice is entirely yours. The GDPR does not set it either way. It just says, if you're going to do this, then do that. If you're going to do that, then consider this. Either way, the choice is yours. So if you do get anyone trying to peddle their wares onto you and say, oh no, you must go digital, GDPR must go digital, don't trust them. They're peddling the digital agenda and trying to use it under the banner of GDPR, and GDPR does not say that at all. Digital should always be your decision and yours alone, not something that's been pushed by something like the GDPR. So data protection is fundamentally, while it is a big piece of law, it is a principle-based piece of law. So if you don't remember the finer detail of it, that's fine. Just remember the 7 basic principles and they'll steer you in the right direction. Because personal data is, as we talked about before, everywhere and in everything, it can't be a hard and fast law like tax law or something like that. It's got to be flexible. It's got to chop and change based on what you're doing. So, for example, the issues that a county council might face are different to that of an NHS trust, are different to that of a manufacturing company, are different to that of a bank. They all, while they're dealing with the same area of law, they all have different problems, different issues. They're all using different grounds of processing. Therefore, they've all got different requirements. So it is complicated, or can be complicated. So the key for everyone, however, is to remember the 7 basic principles. So the way the law works at the moment, while we're still technically a member of the EU, is you have the EU General Data Protection Regulation, and that's a regulation that applies to all EU member states. In there, you've got details of the principles, the Article 6 grounds of processing, Article 9, the rights, and your general accountability obligations. So a lot of what's required is in the GDPR. But again, because it's a regulation that applies to all member states directly, there are some areas where the GDPR should cover but can't, either because it's too complicated or because as part of our membership of the EU just cannot write a law in that area, just can't do it. It's not allowed. That's the whole part of membership of our of the EU. Therefore, member states create what's known as a derogation. That derogation allows them to fill in the blanks, to take the GDPR and apply it to the areas that the EU either just can't cover because it's too complicated, like employment, very complicated across Europe, therefore they don't really set employment law related stuff. They leave it to member states, and fills in the blanks about areas where it just cannot create law. So, for example, national security and defence. There's 2 areas. There's personal data involved in both of those, therefore it can't set a specific law on it. So the GDPR, or the DPA 2018 does, because that's what we set as the United Kingdom. Now, when we leave the EU, what we're planning to do, or what's already been gone through Parliament, is as of the 1st of January 2021, the Data Protection Act 2018 will become the UK GDPR, or it will be referred to as the UK GDPR. When the Data Protection Act 2018 was first published back in 2018, there was something known as the Keeling Schedule. And this was a schedule of the Act itself that Lord Keeling edited, that was basically a copy of the GDPR that was Britishified. So where in the GDPR it refers to things to do with the EU and things like that, they changed it to UK, domestic law, that sort of thing. And that's basically what the GDPR will be for us. So everything you learn here today about the EU GDPR is just as relevant for the UK one, because it's a like-for-like copy. In order to ensure a smooth transition and in order to minimise disruption, all the UK government has done is literally lifted and shifted it into British law, so it's one and the same. Whether or not that will change long term, don't know. There's lots of political posturing about that. But for the short term, at least for the next few years, our GDPR and the EU GDPR say exactly the same thing. So if you're using one, you're using the other. Within the within the DPA 2018, you've got Part 2 that applies to the majority of us, but you've also got Part 3. Now, Part 3 applies to anyone that's doing any law enforcement. So that's criminal law enforcement, so police, courts, those sorts of things. So if you ever interact with the police and they ask you for something, they may well quote Part 3 of the DPA at you. And that's fine for what they're doing, but you need to justify sharing it with them under the GDPR, not the DPA 2018. And we'll talk a little bit more about that in a moment. You've also then got the schedules, and that's where all the exemptions are. So even where all the powers that the ICO or the Information Commissioner is granted as part of the GDPR, they're enshrined into British law through the DPA 2018. So, for example, a fine, we call that a civil monetary penalty, and that's how it's implemented in British law. So if, for example, your enforcement or your power as a law enforcement, so if you're the police, youth offending, trading standards, those sorts of things, then you're covered by Part 3. And if you think you might be, again, we do a 1-hour webinar on Part 3 of the DPA. So if you think you might be, or you interact with law enforcement in any way, shape or form, I recommend going through that. Because Part 3 of the DPA is subtly different. On the whole, it's very similar to the GDPR, very similar. But there are some subtle little differences that you might need to be aware of. So if it's something that you do get involved with reasonably frequently, I highly recommend that. But for the purposes of today, I don't have time to go through it in intricate detail. So I'm just pointing you to where that is. So the 7 principles. 7 things you need to remember, and they're your 7 basic rules. So if someone says to you, oh, can we share this information with this agency? Run it through the principles. 7 basic questions, 7 basic things for you to consider that will point you in the right direction. Because they're principles, they won't give you the final answer, but they will point you in a general direction. You can then find out what that answer is. And some things will be obvious from the word go, as to whether or not it's a go or no go. So, for example, the question, can we share this information with this department? So an internal sharing. Okay, principle number 1, personal data must be used fairly, lawfully and transparently. So is it a fair thing to do? Is it a lawful thing to do? And have you told people that's what you're going to do? Those sorts of things. You've then got the principle of purpose limitation, so only using it for the reasons that you've said that you're going to use it for, or not using it for something else. Minimization, accuracy, retention, security, and accountability. And I'll take you through what they mean now. So, when we look at principle 1, fairness, now once I've said fair, immediately your own minds have taken you to what your own definition of fair is. And fairness isn't defined in the law, so it is literally what you think it is. So many people say fairness is balanced, reasonable, fair expectations as to what your customers, what your patients, what your citizens would expect you to do, what is reasonable. Therefore, what the law says is we'll justify that, outline that, be clear on that, make sure that fits in with the rest of the principles. So if it's something that could be questionably fair, that then doesn't really work with the other principles, it means it's then unfair. Whereas if you've got a strong case of fairness, you've then got a strong case for the rest of it fitting in as well. It's got to be lawful. So if you're using personal data, name, address, date of birth, for example, then you need to match up your purpose with a condition from Article 6. If you're using special category data, so medical information, information about sexual health or sexual orientation, religion, political affiliations, trade union membership, biometric data, mental health data, criminal data, that sort of thing, then you need a condition from Article 9 as well. So for 6, it could be you've got the consent of the data subject. They said, yes, I'm fine for that to happen. Okay, fine. It could be that you've got a contract with them. So, for example, they're a tenant and you're a housing provider. In order for them to give them housing, you've got a contract with them. Therefore, you need their personal data in order to enforce the contract. Fine. I don't need their consent for that. They've signed a contract. Fine. It could be that UK law says you must have it. The law says you, data controller, must have this information from this person if they're going to use your services. Like health and safety, for example, where you're offering food, you have to ask for certain things, that sort of thing. It could be that it's in their vital interest that you tell the paramedic who they are. So they're at death's door, they've collapsed on the floor. You need to tell the paramedic who they are and how they can get hold of the next of kin. It could be that the UK law gives you a power to ask for something. So, for example, the police have the power to ask you for it. You don't have to provide it to them, but they've got the power to ask. A coroner has the power to ask. And if you're granted that power as part of your statutory powers and obligations, those sorts of things, then it could be that it fits under there. For those of you that are not public authorities, it could be that it's in your legitimate interest to do it. So, for example, business-to-business marketing, that's accepted as a legitimate interest. You don't need a consent for business-to-business marketing. You're using your own legitimate interest as a business to contact another business or another organisation about an event or a product you're selling, whatever it might be. But if you are going to use legitimate interests, you have to record what's known as a legitimate interest test. 3 questions. Is it fair? Is it reasonable? Is it necessary? Nice and simple. Keeps it so that legitimacy is something legitimate and you're not just whacking any old thing under legitimate interests. However, if you're using special category data as well, then it could be that you've got the consent of the individual. It could be that your obligations and powers under employment law allow you to do it. So again, it's very rare for you to get a consent for the purposes of employment. It could be that it's under your legitimate interest to do it, or it's part of their contract, or a power that you've been granted under employment law. Again, if they've collapsed at work and you need to tell the paramedic that they are, I don't know, epileptic, that's something that you can share with the paramedic because it's in the person's vital interest that you do that. If you don't do that, you are putting their life in danger. There is a very clear and immediate need there. If it's for the purpose of running a charity or not-for-profit organisation, if it's been made public by the data subject, but I'd avoid that because that's dodgy territory. If it's part of the exercise or defence of a legal claim, if there's a substantial public interest, and this is where if there's a list defined in Schedule 1 of the Data Protection Act 2018, and if you're not on that list, you can't use it. If it's for the provision of health and social care, including occupational health, if it's to protect public health, mainly for things like pandemics and things like that, and for archiving and research purposes. So that for the protection of public health one, where a lot of people were saying, oh, data protection says you can't share information because of the COVID-19 stuff, was utter nonsense. And it really was. There are loads of different ways that health organisations and those responsible for public health can share information accordingly, putting the track and trace issues aside for a moment. The last part of Principle 1 is transparency. So have you told people that's what you're going to do? Have you told your customers, your patients, whatever it might be, that this is what you're going to do and this is how you're going to do it? What it doesn't expect is for you to give them chapter and verse of every single possible thing you could ever do with it ever under any circumstances. What it's saying what the requirement is that the person should understand what it is you do and why you do it. They should understand what's going to happen with their data and what the services are that you're providing. And there's loads of examples where organisations have got this wrong. So if you want to see the areas to avoid, there's quite a few cases. So for example, the ICO explicitly told the HMRC to stop what they were doing because they were recording. So when you called into the HMRC helpline, they were recording that and building that into a database. Therefore, when you rang up next time, they could recognise who you were. They didn't tell you that's what they were doing, and they certainly didn't get consent for that when they needed it. So the ICO told them to stop and reconsider. There's also, again, Facebook, as an example. They're constantly getting in trouble because they say one thing about what's going on with their data, and then it then transpires they're doing something else. So the biggest area of issues around Facebook, and there are a number of areas of issue around Facebook, the biggest one is the lack of transparency. If, for example, you are recording customers' conversations and you are then offering or targeting goods and services out and based on those conversations, then if someone wants that, the customer wants that service and wants you to do that for them, why would you not tell them that's what you're doing? Why would it take investigations to determine that's what you're doing and that it's then creepy? Why are you being closeted and cagey about it? Why not be transparent? If people want that service, they'll buy it. We live in a free economy after all. So that's one of the biggest things of basically issues that Facebook faces. Other things that people need to know is who you are. Who are you? What are you doing? Why are you doing it? How it will be shared or not shared, or how you're going to look after it, how you're going to protect it, what you've got on them, when you might share it with someone and when you won't, where it's being stored, how long you're going to keep it, all those sorts of things. So there's some good examples of some privacy notices online. People do it in different ways. Some people do it via websites, some people do it by handouts, videos, audio recordings, verbal discussions. There's loads of different ways that you can do it. The focus is on your audience. So if you know that you're a charity that works with a lot of children, then gear your things to children. Otherwise, if you've got this nice legally worded GDPR compliant privacy notice, but your audience can't understand it because they're children with learning disabilities or English as a second language or whatever, then it's not GDPR compliant at all. That's why I don't like that word. It's misleading. It's got to be relevant for your audience. So if your audience are kids, write your privacy notices for kids and their parents. If your audience are the over 55s, write for it for the over 55s. All those sorts of things. It's got to be relevant for your audience. And a long legalistic privacy notice is not in of itself GDPR compliant. It's got to be clear. It's got to be transparent. Another thing that could help you with this is in Article 30, there's something known as your records of processing. So under the old Act, the Data Protection Act 1998, we had to register with the ICO and tell them what we were doing. That's gone away. We don't need to do that anymore. But we do need to keep those records ourselves. So we need to keep a record of who we are, so what legal entities we control, what we're processing, why we're processing it, when we're going to process it, so is it frequent, infrequent, those sorts of things, where it's being stored, how long we keep it for, and what protections we put in place to look after it. So it's our record of what we are doing. And if you've got a good one that captures everything that you're doing, who, what, when, how, and why, your privacy notices then become really easy and really easy to manage. So if you haven't done it yet, I'd look at doing it. It's incredible. It takes a long time to do, but it's incredibly useful. So bear that in mind. Principle 2 is then around limited use. So just because I've got it for one reason doesn't mean I can use it for any reason I like. So for example, service delivery is not the same as service improvement. They are two separate purposes. They are linked, but they are separate. Therefore, just because I've got data for service delivery does not automatically mean I can use it for the improvement of that service as well. They're not the same. The analogy I like to use is building an extension and an interior design. Now, in order for that extension to be usable, it's got to have some interior design to it so that it's then, built and deployed, blah, blah, blah. But they're not the same thing. So for example, if I buy in a builder to build my extension, but he's not doing the internal stuff, I'm going to either do that myself or look at another option for that. But if he just hands over my contact details to his friend that does interior design without telling me, that's not fair. And that's a breach of Principle 2. Whereas if he just says to me, hi, I know someone that can do some really good interior design in here. I've used him before, very good, very cheap, might even get you a discount if I pass your details on. Are you happy for me to get him to give you a call? Yeah, fine. Simple. Managing expectations with the customer, being crystal clear what you're doing and why you're not doing, that's what the principle's asking for in its most basic sense. Be clear. Just because you've been commissioned for one doesn't mean that you can then do it for anything else. Just because someone's signed up with the council for their bins doesn't mean you can hand over their details to the library. They're not the same thing. Whereas if someone says, I want that, or someone says, I'm happy for you to do that, fine. You've managed expectations. Perfect. Principle 3 is otherwise known as don't be creepy. Only use what you need. The principle of data minimization. So before lockdown, I used to travel around quite a lot. And I would use, or have to use, hotel Wi-Fi and guest Wi-Fi and that sort of stuff. And often, not always, but often, they would ask you for your name, your email address, your date of birth. Right, yeah, that makes sense. But they would also ask you your gender. And it always puzzled me as to why they would ask you for your gender. So one day when I was really bored, I tested it. So I registered myself as a man one day, tested it, downloaded a few things, accessed some basic websites to see what I could get onto, those sorts of things. Next day I declared myself as a woman, did the same thing. Following day I declared myself as other and did the same thing. Now in terms of what websites I could access, no different. In terms of my internet speed, no different. In terms of functionality and whatever else, no different. So why, oh why, oh why, does an internet provider need to know who the gender is of the person at the end of the computer other than to be creepy? It's creepy. You don't need to know that. It's got nothing to do with the provision of Wi-Fi. It's not a legal requirement for you to collect, like age and whatever else might be. It's creepy. Don't do it. But often in this country, and indeed in the US, we have this thing around analytics. Or we can run a report on more women use our Wi-Fi than men. Good for you. What on earth has that got to do with the provision of Wi-Fi? It's creepy in its most basic form. So principle 3 just says, what's your purpose and what do you need in order to achieve it? Use the minimum possible. Number 4 then talks about accuracy. This is the one that we're all interested in. So you, your business areas, your senior execs, they all want good quality data. But this is the principle that often gets breached the most, because this is the one that's very heavily reliant on human behaviour. So what this says is personal data should be accurate and when necessary kept up to date. This includes making sure you've got processes to ensure it's accurate, not corrupted or changed due to errors, and that staff check email addresses. They don't just fill in the first email address that comes up, because how many Bobs are there in the world? How many John Smiths are there in the world? All those sorts of things, so that the information you've got on a person relates to that person. And there's lots of examples where people have got this wrong. So for example, during the last election, Guido Fawkes, the online news agency, went after Rebecca Long Bailey, but it backfired spectacularly because they got hold of the wrong guy. So they got hold of a Sam or Steve Long Bailey, who was a multi-billionaire, and tried associating her with him, and it didn't work because that wasn't him. Her husband doesn't do anything like that. They then apologised for it, but it was an obvious, you checked the link from Wikipedia. That's just poor journalism. But it was a golden example of, we've found a Steve Bailey, that's him. No, that's not accurate. You've got the wrong guy. And in business or organisational terms, there's lots of examples where people have been sent the wrong posts, sent the wrong letter. This comes up quite a lot in the social housing environment where someone is evicted for the wrong reasons. So in this particular case, someone got the payments mucked up at a social housing environment. It then looked like this woman had not been paying her rent, and actually they'd been paying the wrong person. They then went to evict her, and it transpired that the whole thing was a big mistake. There was also another example where a lady had gone on holiday, and her name and a person around the corner's name were very similar. They stripped her house, threw everything out, so when she came back from holiday, she was left with a completely empty house. But it wasn't her that was meant to be evicted, it was the woman around the corner. Little things, just checking to make sure what you've got is accurate. It seems extreme, but it happens a lot. And it could be little things like the wrong email address. It could be big things like that. But it happens a lot. And it has a direct effect on what you're doing. Principle 5, retention. So only keep it for as long as you need it. Data protection in of itself doesn't set any retention period. So if someone says, data protection says I should only keep that for 5 years, no, it doesn't. What it does is say, well, how long do you need to keep it for? Go away and find out. So for things like tax law will say how long you need to keep it for. Health law, that'll say, medical laws, they'll say how long you keep those records for. Health and safety, handling dangerous chemicals, all those sorts of things. They'll set minimums or maximum retention periods. All the GDPR says is work out what that should be and work out whether or not it's a distraction or whether you're under some obligation or your own legitimate interest to archive it for historical purposes. So all the data protection says is think about it. Consider the entire life cycle, and that's it. Principle 6 is the one about security, which most of you will probably be aware of. Making sure you put adequate controls in place to protect the data. So that includes things like passwords, access controls, antivirus, anti-malware, encryption, firewalls, all those sorts of things. Basically saying, what have I got? How should I adequately protect it and appropriately protect it? Because again, if all I'm handling is, I don't know, last week's shopping list, that means absolutely nothing to no one in any way, shape or form, and I'm locking it down like it's the Queen's jewels, then that's not really appropriate, and staff will think security is stupid. Whereas if it's like, some really sensitive medical files, then it's quite appropriate that I lock it down in that way. That way then staff respond to security is about the threat, not about just the data itself. There are loads of examples where organisations have got this wrong. Some of them are examples where you should have thought about that. So, for example, in this one, thousands of prisoners or 1,000 prisoners' details was emailed to the wrong person. And again, this was an example of people were put into the email when they shouldn't have been. All it required was just taking a little bit of time, not rushing, and that wouldn't have happened. So it's something that could have been avoided. Even organisations like ICSA, they were again fined to £200,000. Again, rather than blind copying people into or participants into an email, they didn't. They put it into the CC field instead. So again, anonymous people that were taking part of the inquiry, their contact details were disclosed. So even something like ICSA, where everything they do is sensitive of one particular nature, can still get it wrong. So you are dealing with human behaviour here. A part of that is a requirement for you to record to the ICO all of your breaches. So a breach is a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorised disclosure of, or access to personal data transmitted, stored, or otherwise processed. So if, for example, someone accesses personal data when they shouldn't have done, a third party, that's potentially a breach. You've lost a piece of a file in the post, that's a breach because you've lost control of it. You've got no idea where it is. That's a breach. You suffer a cyber security hack and people have shut down your systems and taken a copy of it. That's a breach. All those sorts of things. If personal data is compromised in any way, it's a breach. And then becomes a question of whether or not it is a notifiable breach. So in Article 33, what that says is for serious breaches or high-risk breaches, you have to notify the ICO within 72 hours having become aware of it. You don't have to report it if it's unlikely to affect individuals in any way, so it's only for high-risk ones. So things like if, for example, I'm going to pick on some of you now, I tell Goldie where Rachel is living. Now, face value, just an address. So it could be there's no issues there whatsoever because there's no bad blood between Goldie and Rachel. As far as I'm aware, Rachel's not filed any complaints against Goldie. All those sorts of things. There's no threat to the individual there. Therefore, yes, I've disclosed something that I shouldn't have done, so yes, it is a breach, but it is a minor breach, and I can deal with it accordingly. However, if it then transpires that Rachel has complained about Goldie before, Goldie has been stalking her, all those sorts of things. Sorry, Goldie, I'm taking your name in vain, but all those sorts of things. And there is a clear threat to Rachel there now, and I've now told Goldie where Rachel lives. I've put Rachel in danger. Therefore, there is a high risk there. I've got to deal with it ASAP. I can't just whack it through a bureaucratic process and hope for the best. I've got to respond straight away. I've got to offer Rachel support. I've got to tell her this is what's going on, and I'm probably going to have to inform the ICO because there is a clear danger there. So what I have to include is what's gone on, what I think the issues are. Thanks, Goldie. Who's investigating it and what controls I've put in place to deal with it. It's a little bit different for informing data subjects. So again, in that scenario, because there's a clear threat that for health and safety reasons, I need to tell Rachel ASAP. However, if it's something like I've just disclosed Rachel's address but it means nothing, then I don't have to do it straight away. I can wait a little while, perhaps find out what's gone on, so the letter I write them or the phone call I have with them is a little bit more informed, those sorts of things. But it's got to be within a certain within a reasonable time frame. Principle 7 then talks about being accountable. So making sure you've got evidence to show that you are implementing GDPR as best you can. You've got policies and procedures in place. You've done your training and awareness to staff are aware of their obligations. You're managing your risks. You're monitoring compliance. You know what controls you've got in place and whether or not they're working. Those sorts of things. You've implemented data protection by design. You've got done your records of processing, your information mapping, you know what's going on there. You've implemented data protection impact assessments. So questionnaires when people are using personal data say, what are you doing about this? What are you doing about that? So the 7 principles that we've just gone through, it could be something as basic as taking them through the principles. So they consider data protection up front, not at the end. You've got policies and procedures, training. You might have a process for consulting with the ICO. You might go for some sort of formal certification. You've got a breach reporting process. You might have appointed a data protection officer if you think that's appropriate to do and you meet the requirement. You're managing your risks. You're managing your third parties. And you're managing your international data transfers as well. So if you do have any organizations, be those external parties or even internal, you've got offices in Japan, Russia, America, wherever, then you're managing those transfers as well. Key to all of that is your records of processing. So if you've not done your Article 30, your information mapping to find out what data you've got, where is it, who's looking after it, blah, 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 I recommend doing that. It's incredibly useful. Now, linked to all of that is then people's rights, and they have certain rights under the GDPR. So the first one in Articles 13 and 14 is the right to transparency. So very similar to the principle of transparency, they have the right to be told what's going on as well. So either directly or indirectly. So 13 is direct, so I'm collecting it direct from you. So if I'm collecting information from Elaine, then there'll be an expectation that I will tell Elaine at the point of collection what I'm doing with it. Whereas if I'm not collecting it on Elaine, Priya is doing it on my behalf. Then either Priya gives it to her at the point of collection, or I do before I start offering those services. That's in Article 14. So direct or indirect. See what you're doing. You then got the right of access. And again, this is where you should give the data subject a copy of their information and whether or not it's being processed, how long you're keeping it for, all those sorts of things. And again, we do either a 1 hour webinar or a full day course on the right of access. So if you are dealing with any of those, I recommend brushing up on what's required and what isn't. Rectification. So my name's Scott Sammons, spelled S-A-M-M-O-N-S. You can imagine what I'm constantly correcting. Now, if it's just a spelling error, deal with it. So if it's just there's an L in Sammons, get rid of it, done. It's a customer service issue, don't worry about it. Whereas if it's a fundamental, they want to change something because they think that it's wrong. So, for example, they're challenging a witness statement or something like that. Then, again, you might want to treat it as a more formal right to rectification because there are lots of scenarios where you can legitimately say, no, I'm not doing that, or no, that right doesn't apply for that information. So all of these rights aren't absolute. They're very circumstantial. And I could spend an entire day going through them. So this is just a whistle-stop tour. But if you are handling any of the rights, I recommend the full course on them when we go through when they apply, when they don't, and when it's legitimate for you to tell someone no, and how you tell them no. Right to erasure, again, only applies in certain circumstances, especially where the data is no longer required, those sorts of things. Right to restriction. So, for example, if I say to, let's pick on someone else. I picked on quite a few people today. Let's pick on someone else. If I say to Ruth, I'm going to tell you something now. Whatever you do, don't tell Stuart. That's restricting it. I'm restricting what Ruth can do and not do with that data. So it could be you get someone give a witness statement and they say, I don't want you to share this with the person that I'm talking about. They're restricting it. It's then up to you to decide if you can honour that or if it's something that you just can't honour because of the nature of what the data is and what the matter is. So again, it's a very specific and circumstantial right, but it might come up more times than you think. So it's worth especially having a chat with things like HR, health and safety, those that investigate and will take witness statements because it might come up more than you think. Portability. Have the right to have information moved from one place to another, especially only where it's personal electronic data and only where the person first gave it to you and it's being used under consent or contract. So for most of you that are public authorities, it wouldn't really apply to what you're doing. Whereas if you're a business, like a gym, for example, yes, it would apply and they could move from one place to another. The right to object, including the right to object to marketing. So point 1 is around general objection. Point 2 is around objection to marketing. So people can say, no, I don't want you to use my data for marketing, please. Yes, I still want your services, but I don't want your marketing. You also have the right not to be subjected to automated decision-making, including any profiling, except whether consented to it or it's part of entering into a contract, something like a mortgage, stuff like that. An automated decision is where a computer program alone is making the decisions. So, for example, when you go online to compare the market and things like that, a program is making a decision as to whether or not to accept you onto their role, what you will pay, all those sorts of things. That's automated decision making. Whereas if you ring up and an agent does it, that's not. That's just profiling. People also have the right of complaint. They can complain to the ICO, and the ICO is under obligation to investigate it. There's also a number of criminal offences that staff should be aware of. So, for example, the first one is what was known as, under the old law as a Section 55. This is now a Section 170. And what this says is if they steal data in any way, shape or form, they look at it, so access it inappropriately, they take it from you and go elsewhere, they disclose it unlawfully, they retain it, they procure a disclosure, all those sorts of things, then that is a theft. It's unlawful use of personal data. Therefore, it's a breach of Section 170. A 171 is re-identifying personal data from anonymised data. So, the advice used to be make sure you shred your paper records before putting them in the bin. That's still valid advice. But as a thief, why would I go through your bins when I can just go online and look at data sets, create personal data from different data sets, then start identifying people and misuse that data? That wasn't a criminal offence in of itself, whereas now it is. You've also got a Section 173, and that's where, if, for example, let's pick on someone else. Priya puts in a request for information from me because she knows that Leanne and Elaine have been talking about her via email. Now, if either Elaine or Leanne delete those emails after they've been asked for because they don't want Priya finding out what they've been saying about her, that is a criminal offence. It's a record that you hold, rightly or wrongly, it's a record that you hold at the point of receiving the request. Therefore, if you've then deleted it, you're deliberately tampering with records to prevent disclosure. Very similar to what it is with the freedom of information requirements. So staff need to be told that they only, again, be professional, but they should only keep records that they need. Anything that should go should legitimately go, and don't badmouth staff via email. Everyone says staff don't do it. They do. I'm yet to find an organisation where that doesn't go on. So again, remind them not to do it. The ICO has been quite clear, and I do recommend reading the ICO's guidance on subject access requests. It's a very good set of guidance. The final version is due to come out sometime this year, but the draft code of practice, I do recommend a read through. So if you do handle SARs in any way, have a read through of the guidance. The last bit is then around enforcement. So we've already had some areas of enforcement already. The ICO has announced that they intend to fine Marriott £99 million for a data breach last year. That's now been appealed, and the figure is likely to come down quite spectacularly. So keep an eye out for what happens with that. Same thing with British Airways. They're also appealing, and again, the fine amount has already been dramatically reduced. So see what happens with that. They have successfully fined a pharmacy in London after the doorstep dispensary left a load of information in one of their containers out the back of one of their shops in West London. In there were details like medical information, copies of prescriptions, things like that. And the container was, for want of a better word, not in a good way. No way of knowing who'd been in and out, wasn't very secure, and it leaked. So several of the records, or a large chunk of the records, were destroyed because they were just wet and damp and ugh. So again, when the ICO audited them, it then transpired there were a number of things that hadn't been put in place, including effective storage of records. So the ICO fined them £275,000. They've also issued an enforcement notice against the Metropolitan Police for not responding to SARs in a timely manner. So under both the old Act and the new, they've issued an enforcement notice against the police, and we're just waiting to see what happens with that. So there's lots of areas where the ICO has taken action. I also recommend, if you Google GDPR enforcement tracker, There's a website that keeps a record of all the enforcement around Europe. So every single bit of enforcement from each of the member state regulators. It's a fascinating little website. I highly recommend having a look, because you can then see the sorts of things that organisations are getting in trouble with on GDPR. And if your organisation is doing any of them, you can use that as a justification for fixing the problem, because it's kind of already set precedent. A regulator has already told someone off for doing exactly that. So you can use it as a justification for not doing it anymore. So what the powers that the ICO has is they can order you to review something, to look again at something. They can order you to do something, so release something, delete something, whatever it might be. They can come and do a compulsory audit or a voluntary audit. I recommend going for a voluntary audit if it's offered to you, because the ICO won't take action against anything they find in a voluntary audit. So if you want to get them in and do a train drains up exercise and not worry about what they would do to you, I recommend a voluntary one. Whereas compulsory, you're fair game. So if they find all sorts of stuff in your closet, they will take action accordingly. They can issue a decision notice, they can issue an enforcement notice, and they have the power to take regulatory action to issue a civil monetary penalty of up to, well, now £20 million for public authorities, or up to 4% of global annual turnover for what are known as undertakings, so private organisations, charities, those sorts of things. Emphasis on the word up to, not default position of. So where everyone was scaremongering, saying you're going to get a fine of millions of pounds, it's going to ruin your business. As we've already seen, that's not been the case. So it's very much the default position is, okay, tell me what's gone wrong. Then the default position is not, you are a nasty piece of work and we're going to throw the book at you. So bear that in mind. The more things you're doing wrong, the more likely you are to get bumped up the higher amounts. Whereas the less things you're doing wrong, and the more you've got a grip on this, the less likely the ICO is to take any enforcement action against you. So remember that. So, as a summary then, because that's very much a whistle-stop tour through the GDPR, and we've covered a lot in 55 minutes. Remember the basic principles. So print them off, put them up in the office. I've got them on my mug, tattoo them on your arm, paint them on the cap, whatever. Just get staff to remember the basic principles. They don't need to know the inner workings of the Data Protection Act. They don't need to know definitions of the controller, processor, all that other nonsense. What they need to know is the basic principles, because this is a behaviour, not just a piece of law, it's a way of working. Therefore, go in for the basics, and staff are more likely to get it. And then when you want to do more specific training for specific areas, do that. Make sure you record and monitor your compliance rates, because that helps with proving that something's a one-off and a mistake, rather than a systematic part of just how you work. Expect to be appealed on what you do and don't release as part of an SAR, because again, if you tell someone's asking for something and you tell them no, of course they're not going to be happy about it. So expect to be appealed. Records management can help you with SAR and knowing what you've got, where it is, what personal data you've got, all these sorts of things. Rights non-compliance is an area of GDPR enforcement, so if you haven't looked at your rights processes, throw that in and make sure you do that as well. And make sure that remember that the DPA 2018 is a little bit more complicated than the GDPR, but we do have two pieces of law. We have the GDPR and the DPA 2018. And if you've not started looking at what you need to prepare for Brexit or any of your international transfers, especially to the US, I recommend looking at those sooner rather than later as well.